Hello, my name is Professor Angela Daly and I work here at the Chinese University of Hong Kong Faculty of Law. In this short video on internet law, I'm going to talk about internet domain names, how they are governed internationally, and specifically how .hk is governed in Hong Kong. So, internet domain name governance is a good example of the multi-stakeholder governance model. Multi-stakeholderism characterises the way in which the internet has been managed since its birth. Originally, these governance mechanisms were informal and organic, and the participants were a community of interest comprising technical experts, users, network operators, government regulators, etc. The community of interest used deliberation and rough consensus to make these decisions, and these methods can still be found today in the governance of domain names. Prior to 1998, one person, Dr. John Postel, a researcher based in California universities, was in charge of the naming and numbering function. He performed this function pursuant to a contract with the US government. But the internet grew bigger and bigger, and it was not feasible or appropriate for one person to do this alone. So, in 1998, the Internet Corporation for Assigned Names and Numbers, better known as ICANN, was formed to govern the international domain name allocation. ICANN's legal form is a non-profit corporation registered in the US state of California, known as a 501c3 non-profit corporation. From 1998 to 2016, ICANN operated pursuant to a contract and not a statute or international treaty between it and the US government agency, the National Telecommunications and Information Administration, or NTIA, called the Internet Assigned Numbers Authority Function Contract, or IANA Function Contract. In 2016, the US government allowed the IANA Function Contract with ICANN to lapse. There's been a transition of the IANA function out of this contract to ICANN's independent managing of the naming and numbering function. This means ICANN will be fully responsible for the generation and assignment of new top-level domain names. It will ensure that web addresses correspond to the correct website, and it will designate which bodies can hear disputes related to generic top-level domain names. There have been various references to the fact that there is now private or truly multi-stakeholder management of the IANA function since its transition to ICANN. So now is a good time to talk about the different kinds of domain names. I'm sure most people are familiar with www.google.com. The .com part of the address is a generic top-level domain name known as a GTLD for short. Another kind of top-level domain names are those that correspond to country codes. For instance, in the website cuhk.edu.hk, .hk is a country top-level domain name known as a CCTLD for short. Initially, most domain names were one of a few GTLDs such as .com, .edu, .gov, .net, and there were also, of course, the CCTLDs. Since 2012, various top-level domain names have been released. There are some more generic ones like .wine, .shop, .club. There are also some new geographical top-level domains like .london, .amsterdam. Some brands now also have their own top-level domain names like .chanel or .bbc. And furthermore, there are some new community-based top-level domains like .eco, .hotel, .art. Most of these new top-level domains are scheduled to be released in the next couple of years. We have also seen the emergence of internationalized domain names, which include non-ASCII characters. These characters are based on US English. Of course, many internet users do not speak US English as their first or main language. With the internationalization of the internet, it has been important to introduce the possibility of registering domain names in different scripts, such as Arabic and Chinese. So, when it comes to domain name disputes, there are different situations which can give rise to a dispute over a domain name. For instance, when a business name or trademark is registered as a domain name by someone else. cyber squatting, which involves profiting from registering other people's names or trademarks with the intent of either selling them to the company or using the domain name to attract traffic to your own website. Also, we have typo squatting, which involves registering domain names that are very similar to other companies' names or trademarks, but with typographical errors or the addition of a number of letters. People do this for click-through revenue or fraud purposes. There are some issues and problems which arise, in particular the balance between the interests of the company or trademark owner on the one hand versus the potential free speech and competition concerns on the other hand. Problems also arise if parties are located in different jurisdictions to each other or to the domain name registrar. When ICANN was set up in 1998, it was responsible for managing the generic TLDs and issued a dispute resolution policy called the Uniform Domain Name Dispute Resolution Policy in 1999, or UDRP for short. There are various accredited dispute resolution providers which implement the UDRP rules and include the World Intellectual Property Organization in Switzerland and also the Asian Domain Name Dispute Resolution Center in Hong Kong. For the country code TLDs, ICANN delegated their management to designated country managers, which operate the CCTLDs in accordance with local policies. For each CCTLD, there is a dispute resolution mechanism in place, which is usually based on ICANN's UDRP. Why is this the case? Well, using the UDRP and its accredited dispute resolution providers gives parties speed, convenience, and relatively low costs, and they also have systems in place for avoiding cyberflight. Most proceedings are handled online and are resolved within 2 to 3 months. The filing fees are between $500 and $1,500. Registrars are required to lock a domain name as soon as a dispute is filed. But parties are not excluded by the UDRP from also starting court proceedings. So how can you win a UDRP dispute? You need to look at paragraph 4A of the UDRP, which provides that disputes may be commenced when your domain name is identical or confusingly similar to a trademark or service mark in which the complainant has rights, and you have no rights or legitimate interests in respect of the domain name, and your domain has been registered and is being used in bad faith. So there are 3 elements that a complainant must prove in order to win a UDRP dispute. There are 2 remedies in paragraph 4.1. Either the cancellation of a disputed domain name, which is the result of 2% of disputes heard by WIPO, or the transfer of the disputed domain name to the complainant, which is the outcome of 85% of WIPO disputes. There are, however, some problems with the UDRP process, in particular the need to show that the domain name was registered in bad faith. Also, there is no tribunal to which UDRP decisions can be appealed, and decisions of previous panels are not binding on current ones. Some people think that there is also a need to update the UDRP, but this would be difficult to achieve given the competing interests of ICANN stakeholders and the need for consensus. In 2013, ICANN introduced a new Uniform Rapid Suspension, URS, for the new generic top-level domains. These do not apply to the traditional top-level domains such as .com, .net and .org. The URS is designed for the clearest cases of trademark abuse with a higher burden of proof on the complainant. If the complaint is successful, the domain name will be suspended. There are various ongoing issues for ICANN and the UDRP. In particular, there is the concern that the UDRP and other similar policies for the country-level top-level domains give too much weight to trademark owners' interests over registrants' interests. In addition, the UDRP may give more rights to trademark owners than under the domestic trademark law of some countries. And furthermore, some of the evidentiary presumptions may favour trademark owners over domain name registrants. There have also been concerns about free speech, involving the shutting down of domain names, facilitating criticism, and also shutting down fan pages. So moving to .hk and domain names in Hong Kong, The .hk ccTLD is managed by HKIRC, a private not-for-profit corporation. There is a memorandum of understanding between the Hong Kong government and HKIRC to perform these functions. HKIRC has a list of accredited .hk registrars, including its subsidiary, the Hong Kong Domain Name Registration Company Limited. An applicant for a .hk domain must accompany the application with evidence of their entitlement to that name, such as a copy of its business registration certificate. For disputes about .hk domain names, there is only one dispute resolution service provider, the Hong Kong International Arbitration Centre. It is also one of two dispute service providers for the .cn domain and is part of the Asian Domain Name Dispute Resolution Centre, which handles generic top-level domain disputes under the UDRP. If a dispute is commenced through this domain name dispute procedure, decisions of the HKIRC are final and binding. If parties want to use the Hong Kong courts for domain name dispute resolution instead, they need to do this before they start proceedings in the HKIAC. So, in conclusion, generic top-level domain names internationally are subject to multi-stakeholder governance through ICANN. The procedure to deal with disputes about these domain names is the UDRP. For country code top-level domain names such as .cn or .hk, ICANN has delegated their management to agencies in each country or territory to govern them. Disputes about these domain names are usually governed by a similar policy to the UDRP. In Hong Kong, the .hk domain is administered by HKIRC, and if you want to register a .hk domain, you need to show evidence as to why you are entitled to have that domain, such as a company name registration. Thanks for listening and see you next time.